One of our speakers today, Judge Peterson, in the advanced summary of his remarks, makes this observation. If a poll were taken of the non-minority members of the City Club, it's doubtful that even one member would admit that he or she discriminates against minorities in any way. Sure, they might say, there's a problem, but someone else is causing it, not me. That belief, he says, makes very difficult the required education process for change in the treatment of ethnic minorities. Further, the judge notes that many members of society who are not part of a racial minority were raised in a culture in which discrimination was common, even accepted. Yesterday on Oregon Public Broadcasting, a report on All Things Considered examined the question of whether the law and the justice system to interpret and enforce it are or can afford to be colorblind. Among those who were interviewed nationally, there was strong disagreement on the question, even among representatives of ethnic minorities. But several of these folks said we are clearly not living in a colorblind society, that some laws in the justice system are not designed and administered to assure protection of racial minorities, and that this condition must be redressed. With us to provide a local perspective on this issue are two close observers of the way Oregon's justice system addresses members of the state's minority populations and matters associated with race. Judge Edwin Peterson retired at the end of 1993 from the Oregon Supreme Court after 16 years of service. For 10 of those years, he was Chief Justice of the court. During his tenure as Chief Justice, he coordinated transition of the Oregon court system from 36 separate county courts, if you will, to one integrated court system. He led successful efforts to reduce delay in Oregon trial and appellate courts and to promulgate uniform trial court rules throughout the state system. Judge Peterson chaired the Oregon Judicial Department Task Force on Racial and Ethnic Issues in the judicial system for 2 years, ending last spring. State Representative Avel Gordly has served in the Oregon House since 1991, representing House District 19, a portion of Northeast Portland. In this session, she's actively promoting passage of the Racial and Ethnic Justice Act of 1995, a bill arising from recommendation that were put forward by Judge Peterson's task force. Representative Gordly currently is serving on the House Ways and Means Committee, including its Education Subcommittee, on the Committee on Water Policy in the House, and on a House Special Task Force on Sexual Harassment. She was the original program director for the House of Umoja, Portland's safe house for gang-threatened youth. Please join me in welcoming these distinguished guests to the Portland City Club. We'll begin with Judge Peterson.
Thank you, Mr. Barney, members of the City Club, and members of the radio audience. I often listen to the City Club on KOAC, a tradition that I've followed for many, many years. Some have referred to the Portland City Club as Portland's greatest resource. I certainly am pleased to be here and to share this platform with Representative Avel Gordly. I've been given limited time, so I'll get right with my remarks. The Oregon Supreme Court on Racial Issues in the Courts released its report about 9 months ago, in May of 1994. The task force found that racial bias is present in the courts just as it exists in homes, in the workplace, and everywhere in our society. Later on, I'll refer to some of the task force findings more specifically. I have copies of the task force report here, should anyone want to take one with them. There is a quid pro quo, however. If you take the task force report with you, you must agree to read it. You can read the entire task force report in less than an hour and a half, and you'll find that it's very readable. For members of the radio audience, if they want a copy of the report, they should write to the Task Force, Supreme Court of Oregon, 1163 State Street, Salem, Oregon 97310, but it'll cost them $3. Now, my real goal today is to raise your level of conviction. I hope to convince you non-minorities that are present that racial bias exists in you, bias that influences hiring decisions, bias that in subtle but substantial ways continues to cause many racial problems, with a result that's little different from the intentional, overt bias that permeated this United States from 1607 through the 1950s. I'm a 65-year-old Caucasian. Like some of you, I'm somewhat conservative. I used to believe that minorities, and though I'm going to talk particularly about African Americans, what I say may apply to other minorities as well. I used to believe that minorities had made huge gains since Brown versus Board of Education in 1954 and the Civil Rights Act of 1964. I was wrong. In some ways that I hope to illustrate later today, the plight of many of our minorities is as bad today as it was in the early 60s. In 1990, African Americans comprised 1.6% of the population of Oregon. In 1992, 6.4% of all arrests were of African Americans. And in 1992, 13.5% of all offenders in Oregon prisons were African Americans. That's over 8 times their percentage of the population generally. In the juvenile area, the statistics are even worse. In Multnomah County, a recent study showed that 80% of the juveniles charged with crime who are remanded to the adult court for trial as adults were African Americans. Now, why is this? Is it because African Americans are by nature bad people? Is it because African Americans are by nature less intelligent than white people? Does their genetic structure make them more prone to be poor or to commit crime? I sense a caving in of hope that problems of race ever will be solved. Since the 60s, when race relations held promise for the dawning of a new era, the persistence of racial problems causes resignation to many of us. We're fatigued. The fatigue about crime deadens us to the deepening crisis in the education of Black Americans. One can enter almost any desegregated school in America, from grammar school to high school to graduate school to professional school, and meet a persistent reality. Blacks and whites are in largely separate worlds. And if one asks a few questions or looks at a few statistics, another discouraging reality emerges. These worlds are not equal, either in the education taking place there or in the achievement of the students who occupy them. Studies show that African American children and white children test pretty closely in the first grade. But by the 6th grade, in some school districts, Black children are 2 grades behind. The longer they stay in school, the further they fall behind. And this is true in the Black middle class as well as in those less fortunate. And the record doesn't improve in high school. In 1980, for example, 25,500 minority students enrolled in Chicago high schools. 4 years later, 9,500 graduated, and of those 9,500, only 2,000 could read at grade level. College is no different. 70% of Black college students enrolling in 4-year colleges drop out. The dropout rate for white students is 45%, and the grades of Black college students average half a letter below those of their white classmates. And what about graduate schools? In Oregon law schools, in a recent 5-year period, over 12% of the entering law students were minorities. That's good, because that is slightly higher than the percentage in the population generally, or it's close. The average attrition rate for minority students was 25%, 1 in 4. For non-minority students, the rate was 8%, 1 in 12. And keep in mind, this is in a graduate school. In the July 1993 Oregon bar examination, certainly not ancient history, every one of the 13 African American applicants had a Doctor of Jurisprudence degree from an accredited law school. 3 of the 13 African American applicants passed. That's a passage rate of 23%. The non-minority passing rate was 76%. SATs make little difference. The failure rate among African Americans is consistently higher even when compared to students having comparable entering SATs and GPAs. Now why do African American students do so poorly? Professor Claude Steele, himself an African American professor at Stanford, states, "Blacks," and I quote, "blacks face a devaluation that grows out of our images of society and the ways those images catalog people. The catalog need never be taught. It is implied by all we see around us. The kinds of people revered in advertising and movies, media discussions of whether a black can be president, invitation lists to junior high school parties, school curricula, literary and musical canons. These details create an image of society in which black Americans simply do not fare well. Reflect on your childhood. How were African Americans depicted when you were a child? I'd like to read a few lines from a book by a Canadian writer, Robertson Davies. Some of you may have heard Mr. Davies when he spoke in Portland in January. The book from which I'm quoting is entitled The Manticore and is one of 3 novels within the Deptford trilogy. The book is not about race. It describes the childhood of a Canadian boy during the 30s, which happens to be the same point in time when I was raised. Let me quote a paragraph. "It was in late August when I was 8 years old, and it was an adjunct of the fall fair. This was a great Deptford occasion, and in addition to all the agricultural exhibits, there was a little collection of carnival games, including one called Hit the Nigger in the Eye, where for 25 cents you could throw 3 baseballs at a black man who stuck his head through a canvas and defied you to hit him. My grandfather bought 3 balls for me, and I threw 1 short, 1 wide, and 1 right over the Kansas, to the noisy derision of some low boys who were watching, and at whom the black man, obviously a subversive type, kept winking as I made a fool of myself. I remember the movies when I was a kid. Almost always African Americans were cast in servile roles, with yes, sir, and no, sir, comprising the majority of the dialogue. Remember Jack Benny's sidekick Rochester. African Americans consistently were depicted as devalued, and black Americans still are devalued. When I was growing up in a Wisconsin farm community, we tied our horses to a statue of a black boy. I didn't know why, as a child, I thought that African Americans were inferior, but I did. Did some of you? In subtle ways, in ways too subtle to be noticed, blacks remain devalued in American schools. A recent national survey shows that through high school, black children are more than twice as likely as white children to receive corporal punishment, be suspended from school, or be labeled mentally retarded. Sooner or later, such devaluation forces on its victims 2 painful realizations. The first is that society is preconditioned to see the worst in them. Black students quickly learn that acceptance, if it is won at all, will be hard won. The second is that even if a black student achieves success in one setting, with the teacher and fellow students in one classroom, or at one level of schooling, for example, this approval will have to be re-won again and again in the next classroom and at the next level of schooling. And some of you women in this room have had similar experiences in your professional lives. From the first grade through graduate school, African Americans have the extra fear that in the eyes of those around them, their full humanity could fall with a poor answer or a mistaken stroke of the pen. I have here a flyer concerning a minority student conference held at an Oregon law school last year. One of the things discussed at the conference was how minority law graduates could better be able to find jobs. Isn't it interesting that the non-minority students didn't feel the need for a conference like that? In all the large Portland law firms, there is but one African American partner. Why do African American law graduates find it harder to get a job? Whose fault is it that qualified African American law graduates have a harder time to find a job? Is it their fault? It is pointless to preach to minorities about these problems. They know they have a problem. One reason why these problems exist is because people like me, raised in a non-minority culture, are invested with prejudices against minorities, consciously or subconsciously, almost from birth. Without cease, day by day, month upon month, year after year, intentionally or unintentionally, we continue the same conduct that perpetuates the problems that pre-existed Brown versus Board of Education and the Civil Rights Act of 1964. In many cases, perhaps most cases, our conduct is no longer overt, no longer intentional. But for minorities, the result is little different. Is it not up to people like you and me to learn whether subtle prejudices affect our objectivity? There isn't a non-minority in this room who will admit to any prejudice or bias against minorities. But every study that's been done, beyond a shadow of a doubt, shows that subtle biases infect many things that we do. For example, there's strong evidence that judges who are sworn to be impartial are less likely to release minorities on bail, are more likely to sentence minorities to prison, are more likely to give a stronger sentence to a minority defendant, are more likely to depart from sentencing guidelines and impose a stronger sentence on a minority. Now, why is that? The task force report suggests that subtle biases of which we are unaware enter our deliberative process. In the individual case, there may be no apparent evidence of bias, but when you look at the numbers, and they're set forth in the report, there is strong evidence that the habits and attitudes we learned as children carry over into our adult life and influence our conduct as adults. I recently asked a law student why there was an organization at the law school called Minority Law Students Association. I should add that the law student was a non-minority. She looked at me uncomprehendingly and replied, "I really don't know." When I'm teaching, I look out at my law school class, which largely is white, and think, will these non-minority students perpetuate the prejudice of their fathers and mothers, grandfathers and grandmothers? This task force begins with this comment: non-minorities have brought about many of the problems that minorities encounter and are discussed in this report. Addressing these problems and ultimately solving them is the joint responsibility of non-minorities and minorities. Often the greatest challenge is getting those who cause a problem to recognize any responsibility for the problem and agree upon a solution. Our society is filled with persons who nod in agreement that a problem exists and say, "It's them, not me." Government programs haven't eliminated bias. We, you and I, must act. Now, how can we act? I have a few suggestions. Teachers must stop exacerbating the problem by saying to the student expressly, by saying to the minority student expressly or impliedly, because you're a minority, you're going to need special help. That guarantees failure. Some schools have mentorship programs in which adults can become mentors of minority children. The I Have a Dream program here in Portland has been outstandingly successful. Under that program, adult sponsors encourage elementary school children to commit to going to college, promising assistance with college costs and giving ongoing assistance to the children through elementary school and high school. In a small way, one-on-one, minority students receive not a handout, but a helpful hand. Multnomah County is largely white, but Multnomah County has a growing minority population. We, the non-minorities, must address these problems. Otherwise, the statistics I discussed earlier will get worse and worse. If every person here committed himself or herself to mentor one minority child, over the years the tide might be reversed. I repeat, government programs have not eliminated bias. In small but important ways, we can. But to do so, we must make ourselves aware that the problem exists. And that's why the task force report states, and I quote, "The goal is to achieve a heterogeneous culture, one in which racial bias and prejudice, overt or covert, intended or unintended, no longer exists. How can this be achieved? By education, education, and more education. By education of judges and staff to make them aware of and sensitive to the manifold ways in which bias or lack of cross-cultural understanding creeps into conduct." Remember I mentioned at the beginning of my remarks that in 1992, 13.5% of all prison inmates were African Americans. Would you like to know how that compares with 37 years ago? In 1958, before the Civil Rights Act of 1964, African Americans comprised 1% of the state's population, and only 6% of the prison population were African Americans. By this measure, African Americans made no progress in 34 years. I attended a legislative hearing this Wednesday on some bills addressing some of the recommendations in the task force report, bills about which Ms. Gordly will tell you. One minority witness testifying in favor of the bills was asked by a senator, "Do you really think that the courts are biased against minorities?" The response was along these lines, and I should add that the witness was a non-minority. Quote, this is my paraphrase, I should say. "Well, we know that a high percentage of the black population is poor, the crime rate is very high among them, and a high percentage of gang members are black." The unstated inference was that courts are not really prejudiced, that the statistics set forth above and other problems of minorities are due to other conditions, such as being poor or the deterioration of the family. I'll concede the statistics. But why are so many blacks poor? Why is the deterioration of the family greater, if it is greater, among African Americans in our society? Why are most of the gang members, if that is the case, black? Socioeconomic conditions are relevant in considering the problem, but however one looks at it, we must seek to find the cause of these conditions. I submit that the ultimate responsibility for their disadvantaged situation in our society lies with those who create the disadvantages, us. In part, well-dressed, well-educated, even well-meaning people like you and me. You came here today expecting a report, and I brought a challenge. Doing nothing means more deadbolts, more cops, more taxes. Government resources are already stretched. We, you and I, can make a difference. We, you and I, must make a difference. Thank you.
Good afternoon. There is an African proverb that says, when the heart is full, it comes out through the mouth. And right now, my heart is full, very full, with respect for the great man that we have just heard from. And would you join me in thanking Judge Peterson again for a most compelling presentation? I'd like to thank Nancy Hedin and Steve Moskowitz for extending the invitation to speak this afternoon. And I'd also like to thank Nancy for asking me a couple of years ago to join the City Club. I want to thank you for the opportunity to talk with you about the Racial and Ethnic Justice Act of 1995, bills that I've introduced this session. And I want to talk with you about the leadership and importance of the Supreme Court task force that documented the two different justice systems in this state, the one that works for whites and the one that works for the rest of us. I want to emphasize, though, that the issue is greater than today's topic of racial and ethnic injustice in the judicial system. The issue is justice. And I'm here to remind us that justice does not exist if it is denied even to one person in any system. Let me briefly establish the professional background that has prepared me to be a constructive critic of the justice system and an advocate for justice for all people. I am a 1974 graduate of Portland State University's Administration of Justice program. I worked for Oregon as a state work release counselor and adult parole and probation officer, volunteer rape victim advocate in the Multnomah County District Attorney's Office, planning and research intern with the Police Foundation and Portland Police Bureau, Director of Youth Services for the Urban League of Portland, member of the Juvenile Court Advisory Council, and citizen chair of the Portland Police Bureau's Chiefs Forum. In spite of this 21 years of experience, it's amazing that the Judiciary Committee members and other colleagues in the legislature assumed I lacked the background to address judicial issues, probably because I'm not an attorney. I would like to cite with gratitude and great respect two men who served as mentors during my days at Portland State University, Dr. Lee Brown and Dr. Gary Pearlstein, both in the Administration of Justice Department. Lee Brown encouraged me to change majors from political science to Administration of Justice, the program he directed at the time. This was 1974. He cited the opening of opportunities for women and people of color in the various criminal justice fields. And Gary Pearlstein encouraged me in similar ways. They each helped me early on to understand the impact that could be made, that I could make, and they remain inspirational mentors to this day. I was recently reminded of a letter I wrote to the Board on Police Standards and Training in August 1978. This is while I was serving as an adult parole and probation officer. I said in this letter, after 4 years in this system, I continue to observe discretionary justice with regard to treatment of blacks in this system. In that 1978 letter, I detailed several critical areas omitted from the training of parole and probation officers, including racial, ethnic, and cultural awareness, which was sorely needed to address the fact that people of color, specifically blacks, who entered the criminal justice system, including entry through the mental health system, were dealt with poorly and unprofessionally. Statistics I cited in that letter 17 years ago showed blacks disproportionately arrested and convicted and treated more harshly at points of entry in the system. As a woman and minority in a male-dominated occupation, I can tell you it was tough raising these issues within an institution that was totally unsupportive. I was actually reprimanded by a supervisor for raising these issues. This early moment in my professional life revealed that no matter what type of work I pursued in the future, it would include advocating for justice, giving voice to, and speaking up for justice where it is not present. On the opening day of the 68th Legislative Assembly, Oregon Supreme Court Chief Justice Carson remarked to me after his presentation at orientation for new House members that he hoped the task force recommendations you've heard about would be implemented in his lifetime. And I say they can be, if we have the collective will to do what is right and what is just. The significance of the Supreme Court Task Force on Racial and Ethnic Issues and its conclusions cannot be emphasized enough, and so I want to talk again about some of the conclusions. Many non-English speaking minorities appearing in court do not comprehend what is going on and do not understand the justice system because interpreters are not present or are not qualified, and too few lawyers speak and understand the languages of non-English speaking Oregon residents. Too few minority lawyers practice in Oregon, recruitment is inadequate, and too few minorities are employed in Oregon courts. Too few minorities are called for jury duty, and even fewer actually serve on Oregon juries. And peremptory challenges are used solely based on racial or ethnic background of prospective jurors. Judges handling family law cases involving minorities often lack an understanding of traditions and cultural practices of minority families. At every point of entry in the criminal justice system, minorities are more likely to be arrested, minorities are more likely to be charged, minorities are less likely to be released on bail, minorities are more likely to be convicted, minorities are less likely to be put on probation, minorities are more likely to be incarcerated, and in the juvenile justice system, minority youths are more likely to be arrested, minority youths are more likely to be charged with delinquent acts and more likely to be found guilty of delinquent acts. Minority youth are more likely to be removed from their family's care and custody. Minority youths are more likely to be remanded for trial as adults. Minority youth are more likely to be incarcerated. Why are minorities treated more harshly, you ask? Racism cannot be dismissed as a cause. Now, the reality of this legislative climate is that statistics and budget constraints may allow legislators an excuse to ignore or disregard the facts, but the injustice and the racism remain. Nevertheless, the leadership of Oregon's highest court prohibits us from ignoring this issue any longer. I want to commend the outstanding leadership of Chief Justice Wallace Carson, former Chief Justice Edwin Peterson, and all of the people who served on the task force. I commend their understanding of the need to do this study and report to the people of Oregon that we have a flawed and failed system. Most important, I commend them for developing an implementation strategy. This is not a report sitting on shelves gathering dust. I personally distributed the report to all 89 other members of the legislature, and I will leave it to each of you in this audience to find out if your representative has read the report. 13 bills have been introduced that address the subject of racial and ethnic justice. I have introduced 2 of the bills under the title, the Racial and Ethnic Justice Act, of 1995. They are House Bills 2440 and 2441. The bills address the appointment of interpreters for non-English speaking parties, challenge to jurors who make statements suggesting racial or ethnic bias, a procedure for determining if challenges to jurors are based on race or ethnicity, a provision for workers' compensation notices to be posted in foreign languages, a requirement that the Criminal Justice Council develop uniform charging standards and study the influence of race on pretrial release, and another bill or another concept that would increase juror compensation from $10 a day to at least minimum wage for each hour served. In addition, another bill has been introduced by the Oregon Assembly for Black Affairs. It would provide a zero tolerance policy for all forms of racial bias in state workplaces. As a strategy for getting movement on the bills, the Implementation Committee of the Supreme Court Task Force has also introduced individual bills addressing some of the concepts in my Racial and Ethnic Justice Act. And we are coordinating our efforts to maximize the opportunities for discussion among legislators and the public, and to enhance the successful inclusion and passage of the bills in this session's work. We hope to leave this session with these recommendations having been adopted. Otherwise, this legislature will have failed in its responsibility to uphold justice for all people. Currently, portions of House Bill 2441 are also being considered as amendments to Senate Bill 1. And I've just been appointed as ex officio member of the House Judiciary Committee that will hear the bill. Ex officio, no vote, but not without a voice. Senate Bill 1 restructures the juvenile justice system and is the implementing bill for Measure 11 passed by the voters in November. That bill passed out of the Senate this past Thursday, but does nothing in its current form to address disproportionate impacts or discrimination based on race. However, Senate Judiciary Committee Chair Neil Bryant has committed to hearing the Supreme Court Implementation Committee's bills. Those hearings started earlier this week, as Judge Peterson referred to. Representative Margaret Carter and I testified on those bills. And additionally, Chief Justice Carson, Justice Peterson, and myself met recently with House Speaker Clarno to brief her on the task force report. And I believe she now understands the importance of hearing and moving these bills through the House. Jeanette Hamby was instrumental in securing a community-based public hearing of the Senate Judiciary Subcommittee in February at the Martin Luther King Jr. facility. The committee heard community testimony. 250 people showed up, including community-based providers, juvenile justice and mental health professionals, and discussed and affirmed the findings in the task force report. This was also an opportunity for the Judiciary Subcommittee to learn about successful community-based alternatives that have never received the attention and full support they need from policymakers, including adequate funding. Nationally and in Oregon, prevention programs and alternatives to incarceration are advocated and documented to effectively deter crime and recidivism. And it is ironic, given Measure 11 and the public mood, that in one recent survey published by the U.S. Department of Corrections, 157 prison wardens describing how best to fight crime said, oppose building more prisons, and instead they favor more prevention programs, smarter use of prison resources, the repeal of mandatory minimum sentences, and expansion of alternatives to incarceration. The public hearing at the King facility represented a clear opportunity to make change. The community spoke and described its successes and alternatives in spite of this failed and flawed dual system and in spite of a lack of support from policymakers. This group of community folk offered their assistance to policymakers, and it is now up to individuals in positions of leadership and policymaking to seize this opportunity for change and accept the community offer of assistance. We must not let this opportunity slip from our grasp. I should note that Senator Hartung, who chairs the Senate Education Committee, also attended this community hearing. And at a full meeting of the Senate, he described the hearing's personal impact. He described it as the defining moment of his political career and went on to pledge $5,000 to Self-Enhancement Incorporation in acknowledgement of their successful community-based efforts and as a demonstration of the kind of commitment we should all be making to community-based prevention programs and alternatives to incarceration. I hope you have understood that today I am talking to you about institutionalized racism in the criminal justice system, but the larger topic about which we must remain forever vigilant is working for justice for all people. I appreciate the opportunity to share the collaborative work that is going on to ensure that the Supreme Court Task Force recommendations are acted upon in the legislature. For each of you who now may be wondering what you can do, I ask you to call House Judiciary Committee Chair Del Parks at, and this is where you can grab your pen or pencil, at 986-1453, 986-1453, to request a hearing on the Supreme Court Task Force report. And also contact your own legislators and urge that the bills be heard and passed. I would also suggest several books to read to familiarize yourselves with the reality of this society's dual system of justice. The first is Black Judges on Justice, Perspectives from the Bench by Lynn Washington. The second is Black Resistance, White Law, A History of Constitutional Racism in America by Mary Frances Berry. And the third is Faces at the Bottom of the Well by Derek Bell. Let me end by saying that change does not happen unless we make it happen. Each of us has an opportunity every day to speak up for justice for all people. The price we all pay when we allow injustice to continue in the administration of justice is a growing disrespect for our institutions and a real threat to our democracy. Please remember that where there is an absence of justice, there is no peace. Thank you very much.
Thanks to you both for your inspiration, your motivation, and your clear direction to us of what we can do to participate in change. Now it's time for questions from the City Club audience. We'll go an extra 5 minutes today so that some of you can have a chance to ask questions after we hear from the first two. And we'll start with Mona Ozaki, member of the board.
I'd first like to express my personal thanks for your comments. I've really enjoyed your talks today. My work is with children and families for whom the juvenile justice referees and judges are making decisions that are going to impact the rest of their lives. And I was wondering if the two of you could speak and had any comments about what do you think about whether those families are also receiving different sorts of justice based on race and ethnicity.
Well, the task force report does address that question. The question is whether I'll rephrase it a little bit. The question is really whether the juvenile justice system is sufficiently sensitive to the cultural differences of minorities in considering the cases that come before it in which the child is a minority, or could be a situation in which one of the parents or other providers is a minority. And the task force report points out that in the juvenile area, more than any other area, so far as juvenile crime is concerned, the evidence of disparate treatment of minorities is established beyond any doubt. The juvenile area is the one area in which we really have good statistics. Unfortunately, the same is true in other areas of juvenile justice concerning dependent children. And there, the report finds that many of the juvenile judges and other people in the juvenile justice system lack an understanding of the cultural differences that sometimes create conduct that to the non-minority appears to be unsatisfactory. And therefore, the report has recommended that, and I quoted, in fact, the recommendation in my remarks, that juvenile judges, that all judges, including juvenile judges and other people that work in the justice system, receive training so that they're more sensitive to the existence of these cultural differences that can cause actually innocent conduct to be viewed as rebellious conduct.
Mona, the one thing I would add to what Judge Peterson has said is that clearly the report reveals that there is a need for training. What we need are professionals who are culturally competent. But I believe that's also an issue, and the report also indicates this, that is an issue as well for elected officials, including legislators. And what we have before us now in this legislative session is a magnificent opportunity to educate ourselves, starting with the findings in the task force report.
Next question is from Lou Frederick.
I haven't done that in a while. I also want to thank you, too, for being here and some of the statements that you made. I'd like for you to speak to something, though, that concerns me, and I think concerns a number of folks. Many of the statements and many of the issues that you've brought up have been brought up over a period of years. I recall some statistics 30 years or so ago that were similar concerns. And right now we're dealing with what I view as a rhetorical approach from a number of people, including some presidential candidates and state legislators and columnists of one form or another that are saying, we've done enough for these folks. Why should we do any more? We've already given them the chance to get things done. Why should we go any further? I'd like for you to speak to that particular rhetorical approach.
Well, your question, I think, is probably directed to the current movement in Congress and in some of the states to eliminate the affirmative action programs, among others. But just taking your question at its face value, the obvious answer to your question is that we continue to have a significant amount of bias in our society, number one. Number two, The result of this bias is to put some of the members of our society at a disadvantage. If you accept the validity of 1 and 2, the third conclusion seems inescapable to me, and that is those of us that are creating that disadvantaged condition for those who are disadvantaged must correct the problem. It's not up to those who are disadvantaged to correct the problem. It's up to us that have created the disadvantagement to correct the problem. Now, that's a general answer to your question. I think I'll just let my response rest right there.
Lou, what I would add is that it's my belief that there's a great deal of denial in those, what you described as rhetorical approaches, and that if we were just to focus on the issues that we've been talking about this afternoon, which is the findings of the Supreme Court Task Force report, well, there have been at least 30 other studies nationally. And so I would ask a question, how many more studies do we need that tell us the same thing before we act, before we do something to change the behaviors that produce the kinds of results that we've been talking about this morning?
Next question.
Dick Brownstein, I'm a member of the club. During the period of time that the incarceration rate of African Americans has increased, so has the justice system been overwhelmed by prosecutions and convictions and incarceration by drug-related offenses. I'd like to ask each of the members of the panel for their reaction to legalizing some or all of the crimes that are now on the books with respect to the illegal use of drugs.
Well, I can, Mr. Brownstein, I can answer that question very quickly. It's as a judge. As a judge, I'm not permitted to express an opinion on issues that might come before the court. And we judges have traditionally taken a independent attitude concerning what societal changes should be made in the criminal justice area. Even though I'm a retired judge, I'm still subject to being recalled, and so I'd be uncomfortable in giving you the answer to my answer to that opinion, my answer to that question. I apologize.
I appreciate the question, and to be frank, I must tell you that I absolutely do not support the legalization of drugs. I think it is the wrong message to send to young people in this country, and I think the legalization of drugs could only add to an increase in use, and that would mean an increase in some of the conditions that create chaos in some of our communities.
We have time for 2 more questions.
Ted Thomas, City Club member. I read this report last spring when it first came out, and I've gone through it several times. And one of the things that comes across to me is that as an indictment of bias, the report itself is really permeated with bias from page 1 to the last page. And I would ask, if the conclusion of this report, which is so profoundly put forward by it, is so cogent, why is there not one example of an empirical case of bias cited in the report? In other words, why didn't you go out and find some real concrete examples of people being discriminated against, people being falsely accused? I found none.
Well, Mr. Thomas, if you'd read page 1 of the report, it starts out with an example in a courtroom of this state of actual bias by a judge. There's an actual quotation from the transcript.
I consider that anecdotal evidence. This is not genuine specific case. It's just an anecdote.
You have a response?
Is there an answer?
Well, I think we've got an answer. You can talk later if you'd like. Next question.
Andrew Wheeler. Judge, you brought it up. It was affirmative action. The contract for America is looking at dismantling the affirmative action policies in place, and even President Clinton is saying that they should be looked at. objectively, how do you stand on affirmative action?
The task force report doesn't discuss affirmative action as such and takes no position on affirmative action. And I think that's probably the answer insofar as the task force report is concerned. The task force report does, however, point out that the bias that we found in the Judicial Department exists just as well in the workplace, and it does make some suggestions how to eliminate the bias in the workplace, but it doesn't make any express recommendations one way or the other about the elimination of or continuation of affirmative action programs, whatever you mean by that phrase.
The only thing I would add is that when we look at why affirmative action was established in the first place, it's affirmative action to affirmative behaviors so that we are including all people in the workplace. That's why the programs were established.
It's been a great pleasure to have you with us today, and we want to thank you again for joining us. Please join me in thanking our speakers. We're adjourned.